Good afternoon, everyone. Welcome to part 4 of this lecture series on the law on obligation and contracts. This afternoon, we're going to discuss about alternative obligations. So let me share my screen. Okay, we're still on the different kinds of obligation. Section 3 is alternative obligations. We start with Article 1199. A person alternatively bound by different prestations shall completely perform one of them. The creditor cannot be compelled to receive part of one and part of the other undertaking. So 1199 talks about the kinds of distributive obligation. So we have alternative obligation and facultative obligation. Take note of this definition. It is always a source of question in the exam. When you say alternative obligation, this refers to several prestations which are due, but the obligor is to perform one of the choices or the alternates, no? On the other hand, a facultative obligation is one where only one of the prestation is due, but the debtor may substitute another. So the difference in alternative and facultative obligation is that in alternative obligation, there's only one prestation. No? Rather, in alternative obligation, there are several prestations. In facultative obligation, there is only one prestation, except that the debtor may substitute another prestation from the one existing. No? In alternative obligation, the debtor may perform one of the several prestations. Let us go to Article 1200. The right of choice belongs to the debtor unless it has been expressly granted to the creditor. So the choice of making or the right to make the choice or the right to make the choice belongs to the debtor unless it has been expressly granted to the creditor. So the question is, in case that the obligation is silent as to who will choose the prestation, the alternative obligation, then the presumption is that the right of choice belongs to the debtor. Now, the debtor shall have no right to choose those prestations which are impossible, unlawful, or which could not have been the object of the obligation. So again, the general rule is that the right to choose the prestation belongs to the debtor, and there are two exceptions. If the prestation is impossible, unlawful, or could not have been the object of the obligation, or if there is only one prestation practicable. Now, Article 1201. The choice shall produce no effect except from the time it has been communicated. So under Article 1201, communication of notice that a choice has been made, no? The effect of notice until the choice is made and communicated, the obligation remains as alternative. Proof and form of notice. The law does not require any particular form regarding the giving of notice, which may be done orally or in writing, expressly or implied. What is the effect of notice? Once the choice is communicated, the obligation becomes simple. It ceases to be alternative. Now, and the choice is irrevocable and cannot be changed without the consent of the other party. Okay. Article 1201. General rule, all rights may be waived. Article 1202. The debtor shall lose the right of choice when among the prestations whereby he is alternatively bound, only one is practicable. Now, if only one prestation is practicable, then the obligation is converted into a simple one. Article 1203, if through the creditor's act the debtor cannot make a choice according to the terms of the obligation, the latter may rescind the contract and ask for damages. Rescission creates the obligation to return the things which were the object of the contract, together with their fruits and the price with its interest. Take note, class, under Article 1203, if through the fault of the creditor the debtor cannot make a choice, then the debtor can choose rescission and ask for damages. Take note of that article. No? Okay, 1204. The creditor shall have a right to indemnity for damages when, through the fault of the debtor, all the things which are alternatively the object of the obligation have been lost, or the compliance of the obligation has become impossible. The indemnity shall be fixed, taking as a basis the value of the last thing which disappeared, or that of the service which last became impossible. Damages other than the value of the last thing or service may also be awarded. Now, what is the effect of loss of some of the objects? If through his fault the debtor is not liable. If through a fortuitous event the debtor is not liable. If all of the objects are lost through the fault of the debtor, then he is liable. If through a fortuitous event, then the debtor is not liable. That is the summary of Article 1204. Now, in case of disagreement, the creditor must prove the value the last thing is appeared or the service which has become impossible. We go to 1205. When the debtor has been expressly given to the creditor, or when the choice, rather, has been expressly given to the creditor, the obligation shall cease to be alternative from the day when the selection has been communicated to the debtor. Until then, the responsibility of the debtor shall be governed by the following rules. If one of the things is lost due to a fortuitous event, he shall perform the obligation by delivering that which the creditor should choose from among the remainder, or that which remains if only one subsists. Second, if the loss of one of the things occur to the fault of the debtor, the creditor may claim any of one those subsisting or the price of that which, through the fault of the former, has disappeared with a right to damages. Creditor can demand the remaining object, or he may choose the object plus its value or plus damages. Third, if all of the things are lost through the fault of the debtor, the choice by the creditor shall fall upon the price of any of one of them, also with indemnity for damages. If all of the things are lost by fortuitous event, then the obligation is extinguished. Article 1205. Before the creditor makes the selection, the debtor cannot incur delay. Okay, this is the summary of 1205. So loss through a fortuitous event, no, some of the alternative obligation, then the creditor can choose among the remainder. If loss is through the debtor's fault, as long as there are still remainder, then the creditor may claim another item with right to damages. If all of the alternative obligations are lost through the debtor's fault, then the creditor may demand payment of any of the item with right to damages. If all of the things are lost, or all of the obligation are lost due to a fortuitous event, then the obligation is extinguished. 1205 are applicable to personal obligation. Now, the responsibility of debtor is to pay damages depending if it was due to his fault or not. We go to 1206. When one of the prestation has been agreed upon, but the obligor may render another in substitution, the obligation is called facultative. Now, this is the definition of facultative. Again, only one prestation has been agreed upon, but the obligor may render another in substitution. The loss or deterioration of the thing intended as a substitute through the negligence of the obligor does not render him liable. But once the substitution has been made, the obligor is liable for the loss of the substitute on account of his delay, negligence, or fraud. So again, the definition of facultative obligation. Loss of the thing before substitution. What is the effect on the principal obligation? Now, if through a fortuitous event, obligation is extinguished. If through the debtor's fault, the debtor is liable. Now, what is the effect on the loss of the substitute? If through a fortuitous event, the debtor is not liable. If through the debtor's fault, the debtor is what? Also not liable. Okay. After substitution, if through a fortuitous event, the debtor is not liable, if through the debtor's fault, the debtor would still not be liable. No, effect. What is the effect on the substitute? If through a fortuitous event, obligation is extinguished. If through the debtor's fault, the debtor is liable. Again, once the substitution is made, the obligation is converted into a simple one to deliver or perform the substituted thing or prestation. The substitution becomes effective from the time it has been communicated. So what are the differences between an alternative and facultative obligation? As to number of prestations, there are several prestations in alternative obligation. Now, there are several prestations due, but compliance of one is sufficient. On the other hand, a facultative obligation has only one prestation, but the debtor is allowed to substitute. How about the right of choice? In alternative obligation, the right of choice belongs to the what? Debtor, creditor, or third person. On the other hand, in a facultative obligation, only the debtor has the right to make a choice or the right to substitute instead of the original obligation. Okay. What about loss due to a fortuitous event? The loss through a fortuitous event does not extinguish an alternative obligation. On the other hand, the loss through a fortuitous event in a facultative obligation extinguishes obligation. Why? Because there is only one prestation involved. Now, how about loss through the fault of the debtor? In alternative obligation, the debtor is not liable if no, if the right of choice belongs to the creditor, the debtor becomes liable. If things are lost with his fault, he is liable. If the substitute is lost before substitution, then the debtor is not liable. Okay, that's for alternative obligation. We'll meet again for solidarity and joint obligation. Thank you.